Good afternoon, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Loc TV. If you haven't already, you know the routine. Go ahead and hit that like button, hit that subscription button, and turn that notification bell on. I'll give y'all a second to do that. All right, so the previous document, which was for the Fourth Amendment jurisprudence that I got years ago, y'all. I was sending that to everybody, and I'm still going to continue to send that to everyone who emails me about it. That is an older version. This right here is the 2024 version. And this is 128 pages. And this is just a table of contents. This is not even the actual document. I'm about to show y'all the document. This particular document, or in other words, this edition of the document, this 24th edition of the document, I can't email this to y'all. The reason for that is because I actually spoke to the author of this document via email about 3 days ago, maybe 4 days ago, and he expressly asked me not to do that, so I can't do that. But what I am going to do is I'm going to provide you with links to where you can go to get this document. But before I do that, I want to talk to y'all about the author, which is Robert C. Phillips. All right, he's a retired deputy district attorney out of California. So I want to just shed some light on Robert right quick. Shed a little spotlight on Robert. Let me see, where is he at? And I'm gonna read y'all something about him. All right, this is Robert, y'all. All right, so I'm gonna read these little short paragraphs. All right, Robert Phillips, a retired state criminal prosecutor with almost 30 years experience and a former police officer, has been researching and writing legal briefs for decades. He focused on reviewing new case decisions during the last 13 years of his work with the San Diego District Attorney's Office and has continued to do so since retiring in 2007. Specializing in California and federal law, Mr. Phillips is an expert on Fourth Amendment search and seizure, Fifth Amendment Miranda and self-incrimination law, and Sixth Amendment right to counsel issues. He has also authored numerous articles and short legal synopses on other criminal and or procedural topics. Mr. Phillips' reports and analyses have been used by courts, prosecutors, judges, chiefs, and chiefs and sheriffs throughout California. He has been a valuable resource to the California Commission on Post and a contributing author for the California District Attorneys Association, Did You Know, and Prosecutor's Brief. So I just wanted to read that to y'all. Robert, if you're watching this video, thank you for all of this information, regardless of your background, because I know this took you a lot to do. A lot of your time is what I'm trying to say. And that time you can't get back, but it's very beneficial. And I'm going to show y'all why after I show you how you can get a copy of this. And I'll put a link to his website in the comment section of this video, and I'll pin it at the top for y'all. Where was it? Let's go home. I think is this it right here? Yeah, this is it right here. All right, so this is how you can actually get it. So let me go back. I'm gonna close this one out because I want y'all to see it. How I got to it. So once you click home, you click here, right here. You have to be a subscriber to get this ebook. It is extremely long, y'all. It's probably 2 to 3. I would say it's about 3 times longer than the one that's a little over 700 pages. So you scroll down and you click upgrade here. And if I'm not mistaken, you will have full access to what I'm about to show you if you subscribe to his membership, which he's only charging $7.50 a month, which is the equivalent of, looks like $90 a year. That is worth it, in my opinion. All right, so you just log in or upgrade or whatever. You just register, you sign up for an account, and so on and so forth, like that, and then you download it. But let me show y'all how it looks. That's the wrong one. All right, this is just the table of contents. Let me go to the book right quick. All right, this is how it looks. It is 2,177 pages. So, like I said, it's probably about 3 times longer than the one that I'm emailing people. All right, this one I can't give this to y'all because he asked me not to. So that's why I sent y'all. I mean, that's why I'm directing y'all to where you can go and get it from. It's just long. It's 21,000, not 21,000, but 2,177 pages, y'all, of nothing but Fourth Amendment jurisprudence. All right. Let me just show y'all. It is extremely long, y'all. Extremely long. I think what I'm gonna do, since even though I can't email y'all copies of the book, what I'll do is if you see a chapter in here in this video, if you see a chapter in here that you want me to discuss and provide y'all some commentary on and make a video on it, let me know and I'll do that. I actually want to pull up the cases for you and we can read the case. Doesn't matter. To explain this stuff to y'all. This is the most important amendment one of the most important amendments in the Constitution, in your state constitution and in the federal constitution. This one right here is what you need to know. This amendment right here is about 99.999% of the time is always going to come into play anytime you are approached by a public servant, especially somebody in the so-called law enforcement. It's always going to come into play. So it just goes on and on. I don't know how many chapters are in here, y'all, but it is extremely long. So right now we got 20 chapters. Okay, so it looks like about 20 chapters. That's long. These are some extremely long chapters. Table of contents, the outline. I'm just showing y'all how it looks, man. I think I'm gonna do some videos on a lot of these. If you're in California, I strongly advise you, if you're in California, especially if you're in California, to go and sign up for this membership. It's $7.50 a month, and you'll get all of this, what I'm showing you. You will get all of this. This is just the table of contents. I haven't even went through the entire ebook yet. I'm going to call it an ebook. This is just the table of contents, y'all. Nothing but table of contents. Stop and frisk. Was it rule, case law, penal code? Notice they keep saying codes because they're all administrative agencies. The use of firearms, the use of handcuffs, indicators of an arrest. I'm gonna tell y'all something, man. They don't have to use a firearm. They don't have to put you in handcuffs. They don't have to touch you. They don't have to do none of that in order for a reasonable person to reasonably conclude that he is not free to leave. You can be in your house, sitting down on the couch, walking in the kitchen, getting some water and using the bathroom. If you are not free to leave that house when you want to, you are arrested. And as a matter of law, since you're arrested, if the arrest is unlawful, that's false imprisonment. Keep going. See what else we got. Exceptions, factors. So he breaks this stuff down. It looks like this is just 128 pages of the table of contents. That's extremely long for a table of contents. Let's go here. And this is the book. This is the book right here. Let's see, the basics. Police-citizen contacts between law enforcement officers and private individuals can be broken down into three distinct situations, which is consensual encounters, so that's in Chapter 3, detentions, which is Chapter 4, and arrest, which is in Chapter 5. So let's go to the table of contents and see what we get, see if everything is lining up. I know it took him a lot to do this. This is a lot of work, y'all. Yep, there we go, right there, just like we said. Detentions. He spent looks like 100 and something pages, probably 200 pages, just talking about detentions before it gets to the 500s, which is arrest. It's crazy. I'm gonna go to the consensual encounter section in the document, and I'm gonna read that and see what we get. And I'm gonna do arrest. So consensual encounters, which is 251. 251. Let's see. This page 251. No, this is page 49. Okay. 251. There we go. Consensual encounters. All right. General rule. So since this is a general rule, this is a principle. So it should apply all over the country. Contrary to a not uncommonly held belief that law enforcement, let me make this bigger, that law enforcement contacts with private citizens require some articulable reason to be lawful, it is a general rule that any peace officer, a police officer is not a peace officer, just to let you know. But anyway, it is a general rule that any peace officer may approach and contact any person in public or anywhere else. The officer has a legal right to be and engage that person in a conversation without necessarily having to justify such a contact. That is true. If you, let's say you at a park somewhere and you just sitting down on the bench, you're on your phone, you're just minding your business, and a police officer walks up to you and just starts engaging in a so-called casual conversation with you. The conversation may be casual, it may not be he may not be working, but it's just the fact that he did that. If that happens, the Fourth Amendment is not applicable, meaning it doesn't come into play because he doesn't have probable cause and he doesn't have reasonable suspicion to be there. Does that make sense? Anyway, and in support of his conclusion for what I just read right here, in support of his conclusion, he cites these authorities right here. All right, let's go down. The Supreme Court has held that a seizure does not occur simply because a police officer approaches an individual and asks a few questions. That is true. As a common example, in United States versus Brown, the Ninth Circuit is the U.S. Court of Appeals for the Ninth Circuit. In other words, it's the U.S. Court of Appeals for all U.S. district courts in California. There's a few other circuits too. It's probably Oregon, probably Washington, Nevada, and stuff like that too. I'm just guessing because I really don't know, but I know California is one of them. So anyway, all U.S. district courts, anytime you appeal a case from a U.S. district court in California, Oregon, Washington, whatever, it's going to go to the Ninth Circuit. As a common example, in United States versus Brown, the Ninth Circuit found the officer's initial contact with the defendant to be a consensual encounter only based upon the following circumstances. So what circumstances are we talking about? So this is how they come up with their conclusion, y'all. They come up with their conclusion about if this was a consensual encounter, if it was arrest, or if it was a detention, or whatever you want to call it. They come up with their conclusion based on the facts of the case, all right, based on what this officer knew at the time, based on what you knew at the time, based on what happened. There's a lot of factors that come into play. All right. So let's read from this list. All right. These are the factors. All right. The encounter occurred in the middle of the day in public view. Defendant was seated on a block wall when the police arrived, and from which he showed no inclination to depart. Okay, and he didn't have to leave, just to let you know. He can stay there if he had a right to be there, he can stay there. The officer's initial approach was casual and non-threatening, opening with the greeting, "Howdy, guys," and give me a second, y'all. Somebody's at the door. I'll be right back. So I'm gonna start back right here. The officer's initial approach was casual and non-threatening, opening with the greeting, "Howdy, guys," and an open-ended question about what they were doing. See how innocent this sounds? You know what I'm saying? He's just being nice. Don't do that, y'all. Unless you know what to say and what not to say. Unless you know your rights. If this was me, I could tell you right then and there that this was a consensual encounter. If this was me, that this was a consensual encounter. Because I know the law. All right. This is why you need to know the law before they even charge you with anything. You just need to study this stuff so you know it. The officers told defendant and his acquaintances why they were there, a report of urinating in public, accusing the acquaintance of doing that. Really? Crazy. Now, I say this is a consensual encounter because they're accusing the acquaintance of doing it, but they don't have proof that the acquaintance did it. All right. They need specific articulable facts that a crime has been, is being, or is about to be committed. And they don't have these facts in order for them to infringe upon these two guys' liberty. In other words, how do I put this without confusing y'all? They don't have reasonable suspicion to detain them. I'm gonna say it like that. All right. In other words, they don't have reasonable suspicion to detain them to the extent that the detention would be lawful. They need specific articulable facts that a crime has been, is being, or is about to be committed. Most of the questioning was directed at the acquaintance. Questions directed at defendant were generic, asking for identification and whether he was staying at a nearby hotel. It was never suggested that the defendant, let me rephrase it, I can't even get the words out of my mouth, y'all. It was never suggested that the defendant was not free to leave or to decline to answer questions. That right there is extremely important. So this is just my own personal opinion. If this was me and they started asking me all these questions or whatever, the first thing out my mouth would be, am I under arrest? Am I free to leave? Stuff like that. You want to get them to admit that you're not free to leave. So they violate your rights. Anyway, defendant felt free to take a personal cell phone call. Okay. The officers never drew attention to their weapons. In United States versus Brown, the defendant was not held to be detained until the officer directed him to stand up and turn around after seeing defendant reached for his pocket. United States versus Brown, Supra, where an officer's use of his vehicle's emergency lights was held to constitute a detention. I agree with that. The California Supreme Court noted the use of red and blue emergency lights is but one factor to consider. I also agree with that. In so holding, the California Supreme Court noted that a motorist whose car had broken down on the highway might reasonably perceive an officer's use of emergency lights as a signaling that the officer has stopped to render aid or to warn oncoming traffic of a hazard, rather than to investigate crime. Ambiguous circumstances may be clarified by whether other cars are nearby or by the officer's conduct when approaching. So this is very similar to my situation because my car had broke down. This is why I sued the police, y'all. My car literally broke down as I'm traveling down the highway. I mean, like it just everything just shut completely off. It just went dark, and I didn't really have anywhere to park. But it was still in motion. It was probably going maybe about 40 miles per hour, so I just let it coast until it just stopped. But what I did was I was on a 5-lane highway, so I merged in the middle, which is a turning lane. Uh, while in other words, I did that to prevent traffic going north and south. I'm not to prevent, but in other words, to not impede or block traffic, or so to speak. And then I got out of my car, I turned my cell phone light on, just to see what was going on with my car, and also to warn other people who passing by and stuff like that, that, hey, look, I'm out here, I'm broke down, the lights are off. I acted reasonable under the facts and circumstances because, in my opinion, that is what a reasonable person would have done, considering the facts and circumstances. Is this making sense for y'all? I'm not gonna keep. I'm gonna do I do this? I'm gonna stop about right here. A police officer is allowed to question people on the street who themselves are free both to refuse to answer the officer and to refuse even to listen to the officer. People are fully at liberty merely to go on their way. Y'all see this? If the Fourth Amendment does not apply, then that is a consensual encounter, meaning it is completely voluntary. Everything you do is voluntary, unless they do something to make you feel that you are not free to leave. A seizure is an arrest. I don't care if they're calling it a seizure. A traffic stop is an arrest. I don't care if they're calling it a traffic stop. You're not free to leave. A detention is an arrest. I don't care if they're calling it a detention. You are not free to leave when you want to, so you are arrested. And since you are arrested, the Fourth Amendment applies, which means they need to either have probable cause, a warrant, or reasonable suspicion. That's it. Unless you're going to consent to it, and I know you ain't going to do that. A consensual encounter becomes a police officer. Excuse me, y'all. A consensual encounter between a police officer and a citizen does not implicate the Fourth Amendment. Didn't I just say that? Not all personal intercourse between policemen and citizens involves seizures of persons. Only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen, may we conclude that a seizure has occurred. The law does not prohibit an officer from approaching any person in a public place and engaging that person in uncursed conversation. I'm gonna stop right there. Let me go to arrest, which is on page 504. Arrest. All right. I like my version of arrest. So I'm gonna read y'all my version of arrest from my ebook too. Legal definition. Notice they codified it in the California Penal Code, what arrest is. Legal definition: the taking a person into custody in a case and in the manner authorized by law. By law means statute. By law. That's what a statute is to me. It's a bylaw, like a corporation. Corporations have bylaws. That's my understanding of it. Dictionary definition: a seizure, as in the act of taking by warrant or of laying hold on suddenly, for example, when an officer seizes a thief. Case law definition: the Fourth Amendment protects against unreasonable seizures. An arrest is the quintessential seizure of a person. I'm not even sure if I pronounced that word right. All right, let's go here. A person is seized by the police and thus entitled to challenge the government's authority under the Fourth Amendment when the officer, by means of physical force or show of authority, terminates or restrains his freedom of movement through means intentionally applied. When the actions of the police do not show an unambiguous intent to restrain, or when an individual's submission to a show of governmental authority takes the form of passive acquiescence, the test for determining if a seizure occurred is whether, in view of all of the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. The coercive effect of the encounter can be measured by whether a reasonable person would feel free to decline the officer's request or otherwise terminate the encounter. What encounter are we talking about? That consensual encounter that I was just talking about first. This is why you need to read cases, y'all. This is exactly why you need to read cases. In the subsequent case of Torres versus Madrid, the United States Supreme Court expanded upon this theory concerning when a seizure occurs, ruling that a seizure occurs when the application of physical force to the body of a person with the intent to restrain is a seizure, even if the force does not succeed in subduing the person. All right, let me see. I'm gonna give y'all my definition from this ebook. The one that I just did. Give me a second. I'm going to pause the video and I'm going to pull the ebook up. Be right back. All right, this is the ebook. This is my ebook, y'all. Footnote 28. Let's see what we got up here. This is where is it? Oh, we talking about arrest. That's right. All right. Arrest. So this will be in corpus juris secundum. That's what the CJS stands for. Arrest is section 2 as follows. So what is an arrest? The taking, seizing, or detaining of the person of another, either by touching or by an act which indicates an intention to take him into custody and subject the person arrested to the actual control and will of the person making the arrest, or any deprivation of liberty of one person by another, or any detention of him, like what I just said in traffic stop. They like to call traffic stops detentions or Terry stops. So in other words, what they're telling you is a detention, any detention of him is an arrest, like I just said. All right. Or any detention of him for however short a time. It doesn't matter how long it is. Without his consent and against his will, whether it was by actual violence, threats, or otherwise. That's what an arrest is. Anytime you are not free to leave whenever you want, you are arrested. And the Fourth Amendment applies. So they either need to have your consent, reasonable suspicion, or where is it at? It's going to be up here at the top. Probable cause. This is not tricky to me, but it may be a little tricky for y'all. But I have all of the cases down here that you can read. Y'all need to read these cases so that y'all can fully understand this stuff. I'm going to go over probable cause, and then that'll be the end of this video. I know I talked about this in a few other videos, but I'm going to do it again in this one. What is probable cause? Probable cause is a mixed question of law and fact, meaning the facts upon which a police officer concludes that you have allegedly violated a statute, and the elements, i.e. intentionally, willfully, negligently, knowingly, etc., of that particular statute will always determine if there was probable cause, i.e. if you have been lawfully or unlawfully arrested. How do I know that? I found a case that just says, just clear as day it says it. Whether probable cause exists depends upon the reasonable conclusions to be drawn from the facts known to the arresting officer at the time of the arrest. And here's a case right here that supports that contention right there. So that means you need to go and read that case. If you click on it, pops right on up right here, 1972. See that? Now, all of them you can't click on in the ebook, but some of them you can. I'm trying to get y'all the game, man. I'm trying to help you out. You got to read, man. If you don't want to read, you might as well turn this video off because this just ain't for you. It's just not. Probable cause to arrest depends upon whether at the moment the arrest was made, the facts and circumstance within the arresting officer's knowledge and of which they had reasonable trustworthy information were sufficient to warrant a prudent man in believing that the suspect had committed or was committing an offense. All right. This is the ebook for the District of Columbia. Let me make this a little smaller. That is too big. This is my ebook. I finally finished it. I wish I could. I just don't have the time to do it how I want to do it. So this is the best I can do for right now. Unless I have to go out and I have to take care of my responsibilities as an adult. So I got to pay bills and stuff like that. So I just don't have the time to do it. That's why I was asking for donations so I can just focus exclusively on this book. But I can't unless I get enough donations. I'm gonna show it to you. Just scroll through it. I got the addendums. I got a few sample motions in here for y'all. Requests for admissions. These are discovery tools that you use. Requests for production, so on and so forth. Anyway, I'm not gonna I already made the video too long. But anyway, that'll be the end of this video, y'all. Hopefully, you watched it all the way through. That'll be it. The Supreme Litigant is out. Peace.